Welcome, everyone, and thank you all for joining us for today's Purposeful Planning Institute webinar. The title of today's session is Who Needs a Professional Fiduciary? Our guest thought leader today is Marguerite Lorenz, Vice Chair of Lorenz Fiduciary Services, and we also have Kevin Quinn on the line with us today. John A. was planning on hosting today's session, but we're having quite a bit of snow here in the Denver metro area, and it's put a wrench in things out at DIA, so his travel plans for today have changed, so we're going to do our very best in his absence. I do have a purposeful quote that I'll share, and then we'll get started. Our quote today is by Pablo Picasso. The meaning of life is to find your gift, and the purpose of life is to give it away. So thanks again, everyone, for joining us. And with that, we'd like to get started. Marguerite, welcome. Thank you for joining us. And I know as John A. Would like to start this webinar, he would invite you to share a little bit about your purposeful journey, your professional odyssey, how you got to where you are today.
Well, thank you so much, and thank you for everyone who's listening in. And I'm so sorry to hear about the storm in Denver. Stay warm, Julie. I love this Pablo Picasso quote. In fact, I have it here in my office. I didn't know what my gift was when I first came into this work. My stepmother, Jane Lorenz, had started her CPA practice back in 1975. And around 1990 or so, she started being asked to be trustee. And there was no on-point education at that time. The Professional Fiduciary Association of California had not even yet started. Jane is a charter member, was a charter member, and had helped start that organization. And when she and I started talking about the possibility of partnership, I had been recently divorced. I had 2 little boys, so I was a single mom. And visiting her in Fallbrook, California, which for any of you who are familiar with it, it's the avocado capital of the world. And she had a 6.5-acre property, and I moved into a trailer on Jane's property and lived there for 2.5 years in training, learning how to do this particular service. And that's really where I discovered my purpose. Being of service to others in such an intimate, special way. And what I mean by that is that this is tough work. This is serving someone who might have become incapacitated, which means a physician has examined them and determined that they're no longer able to manage their own affairs. Maybe they've resigned as trustee, and even though they resigned, they're still the trustor and still have a great deal of power in terms of what happens with their trust and their assets. And of course, we serve people who have passed away. And in that learning, in that processing, I've discovered the old lady I would like to become. I've had many great teachers, certain clients who've accumulated wealth the hard way. They've earned it. They've bought real estate. They've invested wisely, carefully over time, have saved everything that they can, and now in their 80s or 90s really need the service of someone else who's neutral, who's willing to follow the law, to be sure that everything is documented. And we serve under the 4 basic documents of an estate plan. And that's really where I found my purpose. I love my work, and I love being of service.
Wonderful. Thank you, Marguerite. Would you like to jump in with your talking points here? I think the first question was, how do you define an independent trustee?
Well, in terms of serving as trustee, a lot of us who are on the call probably understand that particular term. It means being the one who's responsible for whatever happens with that trust. And I'll talk about independence in a moment, but I wanted to clarify that, of course, the trust can only operate on those assets that are titled in the name of the trust. The trust could be the owner of those assets. The trust might be the beneficiary of those assets, but it has some limitations. I like to explain that there's the trustor and the trustee, like there's an employer and an employee. Often the trustor, when they first get their trust done, they're funding their trust, titling those assets correctly, and they're serving as the trustee initially. When we talk about independence, we have to focus on conflicts of interest. And we need to understand what those conflicts of interest might be. So we're independent trustees because we are not a beneficiary serving as trustee. We've seen that with families where someone who is bound to inherit is also serving in that important role as trustee. and they have a natural conflict of interest. We've also seen banks and trust companies serve as trustees, and they may do a good job, but they have built-in conflicts of interest in terms of the financial products that they sell. So when we say independent trustee, we mean someone who doesn't have those conflicts of interest. They are not selling financial products. They're not drafting the document under which they serve. They're not a beneficiary of that trust. They're serving independently, and then the series of decisions that are made are adjusted, improved perhaps because of that independence. Shall we go on to the second question, Julie?
That would be great. Thank you.
Sure. Some of the hats an independent trustee wears. So I'm going to focus on the 4 basic documents. By the way, I practice in California. I recognize that some documents might have slightly different names in other states. Please keep that in mind, as the probate code varies from state to state. In terms of the 4 basic documents, the trust is the one that I've already described. Each person has their own will. So if I'm serving a couple, those 2 spouses may very well be the initial trustees of that trust. They each have their own will. The will only operates at death. They each have their own power of attorney for finance, and that power of attorney only operates during life, and again, because someone has become incapacitated or they've given their consent. And that power of attorney deals with those assets that cannot be titled in the name of the trust, such as Social Security payments or the decision to withdraw funds from an IRA to pay for medical expenses. A very powerful tool. And the 4th document is the Advanced Healthcare Directive. I know that it might be referred to as a living will in other places. The distinction in California with an Advanced Healthcare Directive is the Office of Agent for Healthcare. When someone becomes incapacitated, or again, they give their consent, that agent then has the power to make quality of life decisions. Many people consider this to be a pulling the plug kind of power. I don't see it that way because it's very rare in my practice. In the 16 years I've been serving in all 4 of those roles, trustee, executor on the will, agent under the power of attorney, and agent for healthcare. It's very rare to have to actually proactively end someone's life. Instead, the kinds of decisions the agent for healthcare might make is whether this individual, after surgery, who needs to convalesce and get stronger, maybe they need physical therapy, where will they receive that care? Will they go to a convalescent facility for 3 weeks before going home again? Do they have the resources and the kind of space appropriate for doing physical therapy at home? So the agent for healthcare job is a very important job. We see a lot of family members serve in that role because they're very familiar with mom or dad. The challenge I see is still that same conflict of interest, that they may have conflicts with family members because they choose to let mom do whatever mom wants to do as opposed to ordering mom around or fulfilling mom's request to allow her to pass away naturally can be very, very difficult for a family member. So again, the independence of a professional trustee can be very helpful. We tend to have a lot more practice serving people at the end of their lives than their adult children do. And with those resources, with that training, and with that awareness, we're really able to put the client's needs before our own, which is the true sense of being a fiduciary. The next question on the list is, does an independent trustee have freedom to engage beneficiaries at different levels of involvement? And I would say absolutely yes. And the freedom that we're talking about is not being tied in to a volatile family dynamic. So many families, even with good upbringing and plenty of money and lots of time on the parents' behalf to spend with their children, I think children are born with somewhat their own nature and their own personalities. And as families grow, challenges grow. With adult children, and by the way, I have 6 adult children. I only made 2 of them. I'm stepmom to 4, all boys, and ages range from age 28, our eldest, to the youngest, who are the twins, who will be 22 this year. I've had the experience of being with people with really different personalities and figuring out ways to get along. And it's very hard to be objective about your own circumstance. In fact, I would say it's impossible. So when you're already at odds with a family member and then asking that family member to treat everyone else fairly, even if that family member does a good job, they're challenged. They're suspected of having their own agenda. They may have old crimes brought up, like being 10 years old and having gotten the front seat of the car. These are the same people that used to fight over things like the front seat of the car or that piece of cake or whatever those issues were when they were children. So with an independent trustee, we have the freedom to engage beneficiaries at different levels because, one, we've had a great deal of experience with a lot of different families and their challenges. We also understand how the distributions are supposed to be done in terms of the document instructions. And we have to follow the trust. We have to then follow federal, state, county, and city laws. We need to be able to communicate, and not only do we communicate with our clients, but we also have to document our decisions, and we have to document that communication. We are supposed to be able to look back and see commitments made and also follow through on those commitments, but also remember the commitments made by those very same clients. And some beneficiaries need a lot of hand-holding. They don't necessarily know how to document their own financial life. Some people depend on an ATM card and never reconcile their bank accounts with their purchases. And so it becomes a very nuanced level of service when you are making distributions to someone who has limitations on those distributions for good reason, and it's listed there in the trust document. There's concerns about people spending all they have and not saving anything. And so we do get to engage at those different levels and really meet the beneficiaries where they are. And if the goal is hopefully to train someone to be financially independent, then we can do that gently, and we can bring in other resources to help that person learn. If it's just to protect them from themselves, we have the resources to do that as well. A little story might be helpful. We had a client who at age 67, his mom passed away. And this 67-year-old, chronologically 67, mentally and functionally probably closer to 14 or 15 years old. And his dream was to drive a car. And the rules are that if you're going to get a driver's license, you have to go to the DMV like everyone else and apply and take the test. And I facilitated his training by getting him a DMV manual. But cognitively, I wasn't convinced that he could do it. By then, we had engaged an independent life skills counselor because his mom had really done everything for him, and being somewhat limited cognitively, it was great that she raised him to be careful, but he had to learn how to do his own laundry and how to make his own meals. And now he was learning to drive, and we got him some driving lessons. He did not succeed in passing the test. So I never had to say, no, you can't drive. I never had to share my opinion as to his skills. Instead, I could be encouraging and let the process take care of itself. If he had succeeded in getting a driver's license, then we would have been able to take all the usual steps in getting insurance, getting a safe car, making sure that that car was maintained, making sure that he had money for gas. And so many trustees are faced with crossroads all the time, those forks in the road, where we're assisting a beneficiary to achieve their dreams, or we're cautioning them or explaining the budgetary limitations that we have. It's really an involved job. The next question on our list is it cost effective to use an independent trustee? Considering that more than 90% of financial elder abuse is committed by family members, my first answer to the question is yes, it is cost effective. But it may also matter how much we're dealing with in terms of the assets for that particular client. We may or may not be a fit for someone who has only their own home and $100,000 in the bank. But again, it depends on their needs. For a 95-year-old who already has terminal cancer, that may be a perfect fit. For someone who's 45 years old, it may not be. So it's not enough to just look at cost in terms of what is the price for the services of this independent trustee. Instead, we have to look more deeply into the real picture. What's expected? What kind of services are expected? Are we just paying bills, or are we interacting with that particular beneficiary to keep them protected and safe? What's actually involved? I have cases ranging from that individual. I'm proud to say I have a client who's about 104 years old now, and she has plenty in terms of cash. The challenges for her is that her health has had some challenges lately. She has lived independently in the same apartment for over 40 years, and that apartment recently developed mold, and she was reluctant to move. And with a care manager in place and caregivers, and we've had a couple of years of experience with her, not only were we able to get her moved, but the improvement has brought her more energy and more enjoyment. But the cost that she's paying is not just for my services as the independent trustee. Having 24/7 care can be very expensive, especially if you have care in your home. So when weighing the cost of the independent trustee, you need to talk with that trustee about what they charge, when those charges begin. In my services, our charges do not begin until someone has lost capacity, resigned as trustee, or has passed away. And it may be based on a percentage of the assets. There may be an hourly rate. Independent trustees are exactly that. We're independent, and so it's important to ask that trustee directly for their written fee schedule and to talk with them about your expectations in terms of the services that you'd like them to provide. I'd like to get to the next question, which is, how is an independent trustee different from a family member acting as trustee? I've alluded to this difference a little bit already, but this is so important. And even if the family that you're serving has their own business and may have other family members who are part of that business, there is that liability, there is the concern that you still need a decision maker. You know, when we talk about a financial advisor, that advisor must advise the decision maker. Financial advisors are not designed to make decisions on their own. Now, they might have discretionary powers. You might have granted them the opportunity to buy and sell on your behalf. But that statement that comes every quarter, that discussion every quarter or every year in terms of the direction that these assets are going, that still requires a decision maker. Doctors have to speak to the decision maker. So that patient gets asked whether they want this procedure or not. Hopefully they understand the consequences of that particular procedure. They've given it a lot of thought before embarking on a new health journey. But asking somebody else to serve, to be the agent for healthcare, means that, for instance, that patient's rights and that patient's desires have to be looked into. And then there's the liability of the decision that you make and standing strong. In dealing with family members who don't agree, I had one family where the individual trustor, he was quite ill, and he had lived a military life. And during his life, he was estranged from his family. But now he was in the hospital, and he welcomed his mother and his sister to come visit him, and they were born-again Christians, and they just didn't agree about his choices in terms of prolonging his life. And as his trustee, I couldn't decide for him. He was still able to make his own decisions, and he'd made his decisions very clear in writing. He'd made those decisions very clear with his attorney. And as gently as I could, I had to explain to his family that his trajectory was his own, that he had to make his own decisions about prolonging his life or letting it go. And they were very mad at me. I wouldn't let them bring in other people to try to convince him. He had given me pretty strict instructions in terms of their visits. And so as trustee, it meant that I'm not the most popular person in that matter. And his mother and sister refused to speak with me after I gave them his instructions, and they didn't visit anymore. But after his passing, and we were able to get his cremains scattered at sea by submarine. That was his military service. He'd actually served on a submarine. It took about 6 months. We were able to accomplish that for him. It was his deepest desire. And after the ceremony, we were able to forward the video of the ceremony that they conducted on the submarine, along with the flag that was folded over his casket, to his family. And later I received a nice thank you note. But my point is that sometimes family members have a real challenge in carrying out the wishes of someone that they feel they can control or they can decide for. And that's certainly not the job of an independent trustee. We are there to hold up the wishes of that trustor, as challenging as that might be. The next question on this list, a bank trust department will theoretically always be there. What is an independent trustee's succession plan? This alludes to Home Federal. I used to love their commercials and their beautiful bank buildings. They had lots of them. And their tagline on their advertisements was always, "Will always be there." And I get asked questions about longevity. After all, I'm 55 years old, healthy, happy, living life as a trustee. I'm fortunate to have a firm in which I have 3 successor trustees, soon to have a 4th. All of my successors are 40 years old or younger. But not everyone has that. A lot of the independent trustees are solo practitioners, meaning they work on their own. But through the Independent Trustee Alliance, and by the way, if you're interested in looking that up, that's trusteealliance.com, trusteealliance, all spelled out, .com. We have a network. Now, that doesn't mean automatic succession. In your documents, in your own estate plan, you have to contemplate your own successors. You have to contemplate their longevity. If you're naming someone who is your same age, that may or may not work when the time comes. So we have to think about the math. And even as solo practitioners, we have an obligation on some level to get acquainted with some other fiduciaries, other trustees, perhaps in the same locale, perhaps people that we have a meeting of the minds, we're comfortable with their work. And especially for those estate planning attorneys, and I hope we have some listeners today that are in that profession, you know, when you're working with a client to determine who should succeed them, then there has to be given some thought to age and ability and availability. And I recommend having at least 3 or 4 successors in every document, and preferably in the same order for all the 4 documents that I mentioned: the trust, the will, the power of attorney for finance, and the advanced health care directive. So in terms of succession in a bank trust department, banks don't live forever. Sometimes they get bought by other banks. Sometimes their policies change. So if you have a long-standing trust document and an expectation that your local bank or someone you know at the local bank will serve you when the time comes, I think it's wise to actually speak to them, maybe every other year, every few years, to see if that plan will still work. Estate planning in of itself is not a prediction of the future. It is a way for us to elegantly set down our preferences. And if you prefer to have a bank or trust company serve as your trustee, please keep the following in mind. The bank will only serve as trustee, perhaps as executor of the will, but they shouldn't and probably couldn't serve under the power of attorney for finance because they sell financial products. That built-in conflict of interest may not be what you want, and quite frankly, may not serve you in the long run. And they will not serve as agent for healthcare. You may have a bank employee that you like very much, but that person is an employee of the bank and is not named as an individual in the documents. Instead, it would be the bank as a corporation, who also, quite frankly, has a duty to their shareholders before they have a duty to you as the client. This is a real part of their business. And they'll do trust services as long as it's lucrative. I've had the experience several times now in my career where a large bank has been named as successor trustee only to decline to serve because their long-time depositor really didn't have enough cash to interest them to serve as trustee when the time came. It's very disappointing to the client, it's sometimes too late for that client to be participating in making any new choices, because the reason the bank was called to serve is because that client had lost her capacity. So now she has no capacity to make new documents or to select. And instead of having this long-time business relationship step in when the time was right, now had to go to court and have a conservatorship set up so that someone else could be appointed to serve as trustee of her trust. So that's very important going forward. If you're planning on having a bank serve as your trustee, nothing wrong with that, but you have more work to do, and you mustn't assume that the bank will be there when the time comes. In terms of this work, Kevin, I'm going to draw you into the conversation. I'd like to reintroduce Kevin Quinn, who's currently the president of the Independent Trustee Alliance. And again, that website is trusteealliance.com. And Kevin, from the members that we have from the independent trustees that you know, could you share some qualities of those folks? Some of the backgrounds that they have? What are you seeing as a pattern in terms of people that are choosing to be an independent trustee?
Well, Marguerite, what I'm seeing as a pattern of people choosing to be independent trustee is actually not somebody who decides I'm going to become an independent trustee and set out on that path. It seems like it's always more a case of a person who gets started in this line of work does so because they are asked by a trusted client that they have a long-standing relationship with business-wise, who finally says, hey, will you serve as trustee for me? And that seems to almost always be the way somebody gets brought into it. I know others who just have been asked, maybe even from a colleague who says, I have a client who needs a trustee, and I think you would be a good fit for them. Are you interested? And the skills that somebody has going into being an independent trustee appear to be actually pretty broad, and not necessarily everything that immediately springs to mind. I've had so many conversations with people who say, well, okay, so if you're a trustee, you're an attorney first, or are you a CPA? Do you handle their money? Are you their wealth manager? And sometimes somebody comes from that background, um, but certainly not always. It seems to me that a good independent trustee, um, aside from needing a broad understanding of the estate planning process and what's involved, and an understanding of the law and the tax consequences and investing and so on, I think a good independent trustee has to have uh, very solid soft skills, very solid people skills, because just as you were describing with several of the examples that you gave, you're not always the most popular person in the room, and you're not going to be the most popular person in the room. But you have a job to do, and you're trying to help carry out somebody's wishes. So you have to be pretty politic about how you deal with people, and you have to treat each case individually. There is definitely no one size fits all. I often tell people, uh, family members especially, when they ask why should an independent trustee be employed rather than using a family member, I'll always tell them, partially tongue-in-cheek, that at some point you're going to get upset with the trustee. And if it's a family member, then you're going to be upset with the family member. But if it's an independent, uh, at least the family can get together for Thanksgiving and Christmas and the holidays and be together. And if they're going to be upset, at least they're all upset at somebody who's not going to be invited over for dinner anyhow.
Right, right. I love that, Kevin. Thank you. I agree, and I would also add that, as I mentioned before, we have a responsibility for documentation, but we have a responsibility for knowing what questions to ask and being really good students in terms of whatever this new matter is. No two matters are exactly alike, and even if you do have experience serving elders, let's say you're more focused on people that might need certain services. I work with a lot of clients who really need care in their home, or they need to have care figured out for them. Perhaps they move to where the care is. But in addition to that, I deal with real estate. I deal with fine art. I deal with unusual antiques and collections. People accumulate stuff during the course of their lifetime, and we have to be able to work out who receives it, and if someone doesn't wish to receive it or pay for it, then it has to be sold. So there are a lot of different talents used by various trustees. The pattern that I'm also seeing, as you said, Kevin, where people are asked to do this work, I see a lot of people come into this work because they served a family member. Let's say they handled their mom's estate or their dad's trust and had to deal with family members and so on, and felt good about dealing with the math, dealing with the accounting, getting that tax return filed on time. They feel good about turning around a building that was suffering from deferred maintenance, and now the building is in good stead and the tenants are happy. And so we get our satisfaction from checking those boxes and from really making sure that the work gets done. But wherever possible, when we can add a little happiness and joy to our clients' lives, it becomes all the more satisfying in terms of the work. And I really appreciated the question about engaging the beneficiaries at where they are at different levels, because really the trust document has so much information about how those beneficiaries are to receive the bounty that you've left behind. And I would like to talk a little bit about that. When you say that you want your kids to share all of your personal property, that may not be enough information. Did you want us to do a lottery for those items? I've had the situation where I've had to build a catalog, a photo catalog of 6,000 items in a household because the children were so much at war with each other pretty much their whole lives. And even when two would team up and perhaps get along for a little while, they were at odds because there were items in dispute. They all wanted the same things. So if you can give it away during your lifetime, that's great. But also understand that the instructions that you leave, please consider leaving it to the trustee's discretion in terms of how these things will be distributed. Really because, one, if I have to equalize among your three kids, that means that all three kids get an equal amount of money and things. That means everything needs to have a dollar amount assigned to it so that we can do the calculation and make sure that we're fair. Your children may or may not be able to be on the same driveway on the same day, so delivering those items can be expensive. Shipping them, give permission to your trustee to figure all that stuff out. And I know I'm getting into a bit of the weeds, but I thought personal property is a great example of some of the challenges that independent trustees have to deal with, and regardless of whether they're a bank, a family member, or a professional trustee. So just want to give that a little flavor. I'm open to any questions if anyone would like to submit any while we're talking about these topics. Kevin, I wanted to talk about the ITA in terms of supporting people that do this work. If you're listening to this and you know there's someone who's embarking on serving as a trustee, whether they're doing it for a family member or they're doing it for a colleague in a professional environment, please consider introducing them to the Trustee Alliance. Kevin, I'd love for you to share a little bit about why you started the Independent Trustee Alliance.
The Independent Trustee Alliance was started to answer the questions that independent trustees often get asked, many of which we've covered today, and that they boil down to uh, you you seem like a nice person there, fella, and you appear competent, but how do I really know that you can do what you say you can do? And what's there behind you? Is there any sort of industry recognition or industry certification? And what's the succession plan? Are you insured? Uh, so the Independent Trustee Alliance has really started to provide the support and the professional recognition that independent trustees need and deserve. And so the Independent Trustee Alliance currently offers 2 levels of certification for independent trustees. And right now that is based on number and types of trusts managed, years of experience, educational background, and most importantly, professional references. We have a very important component, a specific trustee errors and omission liability policy available for the trustees. And as well as, as you were speaking about earlier, Marguerite, it gives those in the profession or related professions a place to go to find people that they can bounce questions off of and create professional relationships with, because independent trustees are not yet a well-known profession, but as I like to say, uh, one day advisors will say to their clients, you need an independent trustee, and that independent trustee needs to be ITA certified.
Excellent. Thank you very much, Kevin. In terms of the work that we do and being able to have a collegial group to communicate with is great. The education that's been offered, and we continue to work on more educational offers. I wanted to clarify in my introduction, I am vice chair of the board for the Independent Trustee Alliance. I am president of Lorenz Fiduciary Services. So I have a couple of questions up, and thank you very much for sending them in. One is there a legal difference between an independent trustee and a licensed professional fiduciary in California? To clarify, California is the only state in the United States still that has a licensing bureau. There are registries, there are lists, there are other ways that trustees can be found in the United States, but in California, we have a Department of Consumer Affairs Professional Fiduciaries Bureau. If you have 3 or more cases anywhere in California, you have to be licensed as a fiduciary unless you're an attorney or a CPA. Those 2 professions are exempt. I'm sorry that that's so, but professional fiduciaries have a couple of interesting things in terms of their licensing. Every year that they renew their license, we have to submit a list of all of our open cases, all of our closed cases, and explain why our closed cases are closed. For instance, did we distribute out all the funds and now the case is closed, which is a natural termination, or were we removed by a court procedure? Our bureau wants to know and actually reconciles all of those when you say you're not paying fees anymore because now you're retired. We actually have a real licensing bureau. The legal difference between an independent trustee and a licensed professional fiduciary may be you could be an independent trustee if you have 1 or 2 matters, but again, once you have that 3rd, in California, it's unlawful to be unlicensed to do that work. So I hope that answers your question. In terms of who and who cannot serve or market their services, again, it's based on the licensing in California. In other states, I'm not that familiar with the laws, but I do know that the Independent Trustee Alliance serves the purpose of having a place to find someone who's at least been somewhat vetted. We do have a membership process that includes sharing referrals with us so that we can see what your reputation is and so on. So at least there's some process that when you call yourself an independent trustee and you're a member of the Trustee Alliance, you have some weight behind that. I have another question. With respect to the healthcare directive, where you may not have the ability to understand the full realm of wishes for the client, how do you or do you engage with family members as part of the decision-making when you are named as the agent? That's a great question. There are challenges. If your advanced healthcare directive doesn't have information about particular procedures, it is nice to get some history from the family in terms of your preferences. But in terms of decision making, it is up to the agent to make the decision. So when I see words like consult with family members or ask family members their opinions, now we might be getting into an area of dispute. I try my best to work with the medical community. Hopefully a client has had a history with a particular primary care physician, maybe has already had some experience with caregivers. In terms of family members, because they're also beneficiaries, I have to be cautious about the advice I receive from them, but I certainly welcome their input. Like if they know mom is allergic to nuts, or mom prefers strawberry ice cream over chocolate, or likes her TV really loud, those kinds of bits of information are so valuable to make someone's quality of life as good as it can be for their last days, their last years. It's very important that that person's wishes are upheld as best we can. Some things are just not practical. I've had situations where a family member is living with the elder in the house, and there's some confusion. Is that person living there because mom's paying all the bills and it's convenient? Or is that person living there because they're of service to mom and they pay rent? The hours that some of the family members work to serve their parents or their other family members are not documented anywhere. The benefit to that person is not documented. So I walk into situations sometimes where it appears like financial elder abuse instead of loving care. And so if you're embarking on taking care of a family member, if you wish to participate in the decisions about their care going forward, those communications need to happen while someone still has the capacity to write those instructions into their documents. It's great if the estate planning attorney knows about that relationship and can help support it, again, in the drafting of the documents. When someone finally loses capacity, they're not able to understand new information or the consequences of the choices that they make. It makes it very challenging, and very challenging for family members who just want to help. So I think communication is really at the root of the best estate plans that we can administer. So I'm welcoming more questions if anyone else has anything else.
There's another one here, Marguerite.
Sure.
Why would a bank refuse, going back to what you were discussing about banks, why would a bank refuse? Weren't they aware of the trustee designation before it kicked in?
Oh, good question. So honestly, trustees are not always aware that they have been designated before it kicks in. In my practice, when I speak to a prospective client, I ask to have the documents sent to me once they're completed, so I have a chance to get better acquainted with what you want. But that's not always the case. I've been called by a doctor asking me to make medical decisions for someone I'd never heard of before. My name is well known. I appreciate that people trust me, and they've named me in their documents without letting me know that they have done so. Banks are not that different in that they may or may not be aware. Depending on the assets that we're talking about, depending on the client, depending on that bank, some banks have specialized language that they really want to have put into the trust documents so they can keep selling their financial products, so they can keep their particular business style. But in the declination that I described, it's really because they didn't have enough cash. Many, many banks have a minimum. So for instance, in this particular case that I brought up, their minimum is $1 million of liquid assets, meaning it's either stocks that can be sold easily or it's cash, not the real estate. The real estate does not count towards that minimum. And this particular individual had $900,000 deposited with the bank. when the bank's committee came to decide about whether or not they would take it on and accept the role as trustee. And by the way, there's no slavery in trust work. You can be named as trustee, but you don't have to serve as trustee. You have every right to decline if you don't want to serve. And in this case, the bank declined because it did not meet their minimums, even though they had been listed in this lady's documents for over 20 years. So the bank is going to make the decision that is beneficial to the bank. They have to do that. They sell shares to their business, and so they have to put business first. It doesn't mean they were cruel. It doesn't mean that there aren't nice people who work at the bank. That the decision's not based on how nice they are. It's really based on business. For myself, it's rare that I've had to decline to serve. There have been situations where the client had absolutely already set up everything to go directly to family members, leaving no cash and no property in the trust. So there was no point in serving as trustee in one particular matter I can think of. So that's another consideration. If you go through the trouble of having an estate plan, but you go to the bank and you make every bank account you have pay on death to your beneficiaries, regardless of their circumstances, whether they're living or dead, whether they're on public benefits or not, you're really thwarting your own estate plan. So it's worth considering that the work with your attorney is not just in getting the documents completed, it's actually in making sure that your estate plan will work when the time comes.
And there's another question. What do you recommend someone do about medical and financial power of attorney and trustee selection who is single, has no children, and has family members who live in other states? I'll answer that one first because I have a lot of clients who fit that profile. And I would recommend that they interview an independent trustee or professional fiduciary who is local to where they live and see if that's the right answer for them. But if they do name somebody, in the case of someone who has family members maybe live in other states, if there's any contact at all between the client and those family members, it's a good idea that they are aware that the client is named somebody other than family in those capacities. It's always unpleasant when the professional fiduciary or independent trustee finds out that they were named in a document when somebody has passed away or has lost capacity. Marguerite just spoke about that as well, and
yeah,
it happens to all of us, and that's not the time to find out.
Well, I would like to say that if you're single, it's important that you talk to your estate planning attorney about what your options are. Your financial advisor should not also be your trustee for the same conflicts of interest that the bank has. You know, the person running your money also may have rules. Their own broker may forbid them to serve as your trustee. You might want your CPA, somebody that you know and you trust. Because they're a professional, they're good at documenting, but they may not have those soft skills that Kevin described earlier or be able to serve as your agent for healthcare. So as a single person without family you can rely on, you have a little more research to do. Kevin and I and many members of our alliance have been discovering that there are lots of independent trustees. We're just finding each other now. We're just helping each other now. And I hope that if you know anyone who's serving as an independent trustee anywhere, that you let them know to find us, because we're hoping to be a resource for single people. We're hoping to be a resource where you can look up local solo practitioners, local firms that serve in these roles to help you. We have another question up. Have you seen more uses of independent trustees as a co-trustee and also trust protector roles? Co-trusteeship is not something that I'm personally interested in. I recognize that some people want to maintain control that way. I think of it as putting two steering wheels on the same car. If you're doing driving lessons, it might be helpful, but once you finally have a destination and so on, having two people that need to sign every check, There can be a lot of challenges with it. I know there are some trustees that welcome that kind of work, and different folks have different feelings about that. Trust protector is an interesting one because I don't think the law is really clear about the trust protector's duties, certainly not the fiduciary duties, and not the liabilities. If I'm asked to be a trust protector, I'd like to see that accounting every year. I don't want to be called when there's finally a problem 5, 10 years in. I really want to be aware of how things are going, and I expect to be compensated for that work, and I expect to have some authority based on the document to make changes if I see fit. That also challenges the role of the trustee. The trustee is ultimately the one who's responsible for what happens in that trust. And to have co-trusteeship or to have a trust protector may set those professionals at odds depending on what is interpreted in the document. And I think our courts are a way to resolve some of those disputes and those questions without the need of having these other protections. People have different feelings about it. I respect that and may have different experience with it. And again, I'm speaking from my limited experience here in California. We're getting close to the end of our presentation. I'm really interested, if you have further questions, that you reach out to us through trusteealliance.com. We are always learning. We are always seeking the best practices. We want very much for people to live their lives independently and in a healthy way and be able to fully participate in their own lives. And I feel the best way to accomplish that is to plan ahead. If you don't yet have your estate plan completed, please get working on it. If you know other people you love, even people you like, even people you tolerate, and they don't have an estate plan, please encourage them to get that done. I know there's a lot of do-it-yourself out there. You know, none of us can be objective about our own circumstances, and that relationship you have with your estate planning attorney is precious. If your ideas, if your intentions are ever challenged, you'll want to have that professional in your corner who has notes about your discussions and can really speak to your intentions in terms of preparing your plan. So I encourage you to get it done. Kevin, do you have anything else you'd like to add?
Well, Marguerite, thank you for leading everybody through this. Hopefully for some people this was an introduction to a new service that they can offer to their clients or suggest their clients look into. The role of independent trustee is greatly varies, just like Marguerite was saying. Some will hold multiple roles, some will only do one or two things. And each one, though, is doing the job because they really actually care very much about doing the right thing for their beneficiaries and following the trustor's wishes and not letting families get screwed up along the way. So thanks again, Marguerite. Julie, thank you for hosting us in John A.'s absence, and look forward to seeing you all at Rendezvous next summer.
And just as a final thought, you know, independent trustees don't sell financial products. They're not drafting the documents under which they serve. We are thrilled and happy to work with other professionals, especially those who are custodians for those funds, financial advisors who want to stay working with their clients, might want to seek out independent trustees because the bank has their own financial solutions. And I have nothing against banks or trust companies. We all have our place. It's a big universe in terms of the services we provide, and we're allowing individuals to pick the professionals with whom they'd like to work. And there's a lot more out there in terms of education. And I look forward to seeing you all at PPI. I'm thrilled to be a member of the Purposeful Planning Institute. I've learned so much, and I really appreciate that we're all doing our best to bring love to our professions. Julie, is there anything else you'd like us to cover?
Well, I think you guys did an amazing job. Thank you so much for sharing your time and expertise with the PPI community today. And I'd like to thank everyone who logged in for sharing your questions and comments with us. So unless there's any other comments or points you'd like to make, I'll go ahead and just announce our upcoming webinars.
It sounds good. Thank you.
Great. Thank you so much.